She looking like me. Everyone always commented about me sipping my drinks and shit. Stay out of my business.
That the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang.
Dude, this is scaring me the way she's breaking it down here. I'm like starting to feel like they're going to do a guilty verdict. This is starting to scare me. Day 167 of the YSL RICO trial was the final day of the trial. The judge charged the jury, and now they have to decide the fate of Yak Gotti and Shannon Stillwell. On Wednesday, as you're watching this video, deliberations are starting, and they have until 3 p.m. If they don't have a verdict by then, they go home for the weekend over Thanksgiving. So there could be a verdict today as you're watching, but I don't know. The way the judge was instructing them and everything, it really favors a guilty verdict. Like, it's just scary. This whole situation's very scary because I want it to be not guilty, but I don't know. I think it could be a hung jury. I don't know, dude. Hit subscribe, join channel membership. Let's go, boys.
An email yesterday evening that has what we think are the last things we need to take a look at. So if we want to just walk through those.
Just for consistency, I would put the not guilty first and then a guilty.
I agree. Don't know how that one happened. Ms. Percival, can you switch those around?
Your Honor, I'm going to object on count 2 and count 49.
Yes.
I don't think you should be putting the victims' names.
Why?
He's objecting to having victims' names in this somewhere on one of the counts.
In fact, you need to give me a reason.
Because, I mean, I think it's clear what the 2 counts are. If we put a date on it, I wouldn't necessarily have a problem with it. I mean, I think it's clear that my client's charged 2 murders. I don't think it's necessary to put the victims' names next to each count.
I mean, we all know why he's asking for that, right? It probably won't really make a difference, but clearly a juror not seeing the victim's name is better for defense.
All right, well, I appreciate that objection. I overrule it. All right, so looks like at least the verdict forms are in their final form.
All right, verdict forms are done.
As y'all can see, and from the email, I determined that Overact number 175 shouldn't be in there because it seems to not assert one of the necessary elements to have made that a crime.
So she doesn't want to send back Overact 175?
I understand the thinking behind it, but I don't think that's consistent with Georgia law. I think we've already established and the court has recognized an Overact doesn't have to be a crime, and therefore we would not have to have all the elements present. So,
You are asserting the crime of, did commit the felony offense of whatever, OCGA section whatever. So
under Georgia law, and federal law is consistent as well, the state does not have to allege all of the elements of an overt act that does happen to be a crime because it is not separately charged. The pleading rules are not the same. You can't generally demur to an overt act. And so while it might not be adequate as a freestanding charge, an overt act telling the jury what we are saying was done, that would still be sufficient. They don't have to decide it's a crime. They just have to decide it's an act in furtherance of the conspiracy because they're not separately convicted of this.
I don't agree. If you have law that is on point, show it to me. But if you are asserting he committed the felony offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm, and you cite 1611-133, one of the essential elements of that is that he's possessing it while he's committing a crime.
So this is about that part of the indictment where they completely messed up.
I understand, Your Honor. As far as it not needing to be a crime, Yates versus United States, 354 U.S. 298.
That says if you assert it as a crime inside a statute, it still doesn't have to be a crime? I know an overt act doesn't have to be a crime. Are you saying that Yates is going to tell me that if you assert he committed X crime, you don't have to actually be asserting a crime, even though you're saying pursuant to XYZ statute?
I'm citing Yates for the initial principle.
That I understand.
Okay. I'm not representing to the court that Yates says all of the additional things you said. I don't have a cite off the top of my head, so I'll simply have to represent this to the court, especially when, like the ones we're talking about here, there's more than one actor involved.
There's not here for 175. There's only Mr. Nichols.
Okay. I still don't.
All right. Again, if you find some law that is on point, you let me know.
All right.
Your Honor, by that reasoning,
If you find some law, we'll deal with it further.
I mean, yeah, he doesn't have any law to help his position here. Max is still trying to argue something.
I agree with the court,
Okay.
but I'm wondering if that should also not apply to 174, 189, and 190.
So he pointed out more overt acts that he thinks shouldn't be sent back because of the error.
174 and which others?
189. Oh, sorry, go ahead.
189 and 190.
Those present the same situation.
Sounds like she's not going to send those back either.
Yeah, I think you're correct.
First look at the boys today. Yak Gotti got the cardigan on. Shannon looks nervous. This is definitely the worst time for a defense lawyer and defendants, by the way, because at this point, the jury's about to decide their fate, essentially.
Like, for instance, on Mr. Stillwell's March 17th possession of a firearm allegation, it's also a substantive count 64, and it's saying that he did that on March 17th, and we know from the evidence that what everybody is talking about is the gun that, I don't know if it was thrown out of the car, but the gun that was discarded during the chase. And, you know, I mean, I think we were looking at sort of the somewhat odd language of 1611-133.
Really, when it comes down to it, the state did not indict this correctly, and the state did not put it in the overacts correctly, and they specifically alleged a specific crime in the overacts.
Yeah, it's their L, right? State keeps arguing this, but they never bring the case law that supports it.
So we moved for a directed verdict on the substantive charges, and Mr. Abate and the state provided case law that saved that and opened up the possibility for a lesser included, and I get that. But I don't see that same mechanism of saving the charge for overt acts.
Right.
And so that's kind of where we're at. Essentially, I'm suggesting that there should be a directed verdict on the overt acts.
I think those overt acts need to be removed. 174, 175, 189, and 190.
A win is a win. That's a W for the defense right there. All right, here's Overact 174. Defendant Shannon Stowell, possession of firearm by convicted felon of previously convicted. A felony involving the use or possession of a firearm on March 14th, 2022. Cormerius Nichols, possession of firearm. And the issue is they put 1611-133, which is the wrong. 189 is Yak Gotti, possession of firearm by convicted felon when he got arrested at Thug's house. All that bullshit. Wasn't even near any of the weapons or anything. Kind of crazy that they even charged him with it. And then Shannon Stowell, possession of firearm on the day he got arrested in 2022 for the Shamel Drinks murder. It's their Al. They fucked up the indictment. This is how it should go.
Your Honor, may the state briefly address that issue?
Here we go. Adkins nerd ass.
Some of the reasons, that Mr. Floyd was just articulating about the case law for a substantive count of 133. As the court, as we have addressed, you can have the possession of firearm by convicted felon because it's a lesser included. Legally speaking, the argument for, an overt act language, which does not have to have as much specificity as a count that the jury is deliberating on. The first language in 190, for example, is possession of firearm by convicted felon. It obviously has the superfluous language because it's not completed of the underlying felony, but that same logic for a count, which has to be more perfected than overt acts do, because overt acts do not have to be crimes.
I understand they don't have to be crimes,
Yes,
but they've been alleged to be crimes with specific statute numbers, and yet y'all haven't included what would be essential to make them a crime. So are you arguing that the overt acts should be lesser included also, or what are you saying? What's your argument?
Your Honor, my argument is that if the jury is tasked to decide if on March 17, 2022, when Shannon Stillwell possessed the firearm by a convicted felon in furtherance,
previously convicted of a felony involving use or possession of a firearm.
Yes, Your Honor. In the state's mind, the lesser included argument on a substantive count, a harder standard to meet than an overt act. There's no such thing as like a directed verdict on an overt act as there is with substantive counts. And so the state believes that same legal principle of why a lesser included of possession of firearm by convicted felon can be included on a substantive count is even stronger on an overt act.
So I'm clear. Are you asking that these be converted into just possession of a firearm by a convicted felon in the overt acts? As kind of a lesser included crime?
Yes, Your Honor. And if the state, for example, if the state, from my understanding, were just to redact, essentially, yes, Your Honor. And I'll let Mr. Floyd.
I think that there is evidence presented for that. And I hope y'all understand what my thinking is on because 133 requires that it be asserted that they did this while they were attempting or committing a series of crimes listed or types of crimes listed in the statute. And that is in nowhere listed in your overt act. That seems to be problematic. But
extremely problematic.
Frankly, only the fact that he had the gun during the course of the conspiracy is enough for it to be an overt act. He is in possession of a weapon.
I know y'all didn't allege it that way.
Well, that may be so, but it still does the work under it. I mean, it wouldn't.
Being an adult has its high points because you could eat ice cream for dinner and watch movies all night. You could do whatever you want. But you also have to do the not so fun stuff like taxes or booking doctor's appointments. And for that one, there's ZocDoc, boys. Listen up. I just got my wisdom teeth taken out through ZocDoc.com/CUFBOYS. ZocDoc is a 100% free app and website where you can search in-network doctors and book your appointment instantly. We're talking about in-network appointments with over 100,000 healthcare providers across any specialty. From mental health to dental health, eye care to skin care, and much more. Plus, ZocDoc appointments happen fast, typically within 24 and 72 hours. You can even score same-day appointments, which I did. This is 100% a real story that happened to me in the last week. My teeth started hurting really bad on the top. Looked up oral surgeon, found a consultation, scheduled it through ZocDoc's app, went to the appointment the next day, and then I had surgery 2 days later. It was absolutely incredible. ZocDoc was seamless. And I was putting it off for a while because I was terrified of going under, so stop putting off those doctor's appointments. Go to ZocDoc.com/CUFBOYS. Find and instantly book a top-rated doctor today. That's ZocDoc.com/CUFBOYS, ZocDoc.com/CUFBOYS. Go book your doctor appointment right now, boys. Appreciate you guys. Here's the rest of the video.
They cannot return. I find overt act 190 he committed this crime when you have not asserted that every element of that crime. They can't possibly find that when it hasn't been correctly asserted. Y'all have left out an element.
Hit the nail on the head, Judge. Right there. Take your L. Sit down, Baldy.
Unless you've got case law, you're not going to convince me on that one. We have moved on to whether it should be redacted, modified to essentially assert a Section 131 crime of simple possession of a firearm by a convicted felon. And I think that has been sufficiently asserted in each of these overt acts.
Excuse me, and the state may be able to find a case, but I haven't, and you may be aware of a case, Your Honor, and in my limited time I haven't found one, but I don't believe that there's a case that permits the court to go back and fix.
I do not have any idea whether there is.
Yeah, I do not believe that you can go back now and fix the error that they have made, or whatever, fix what they have done at this point in time by modifying the allegation of this overt act at this point. I just don't think you can do that. I think the only option is to redact it, Your Honor, and I think it would be error to go ahead and change that.
I don't know. So
because that's what we have been. I'm
sure we'll have some time between now and when we actually send it out for somebody to do some research on that. So we'll put a pin in overt acts 174, 175, 189, and 190. They're absolutely not going to be included as a 133 offense. Y'all can let me know if there is case law out there that answers our question on the floor right now of whether they could be converted into a 131 offense, since it at least asserts that. But I don't know whether we can change it like that. So
this guy has some good tweets. He said, in the reindictment, the state changed the way it alleged the possession element of 1611-133, essentially revisiting the elements of the crime and making it easier to convict. Shady shit right there. 1611-133, use of a firearm in felony by a person previously convicted of certain felonies, requires proof that the defendant had a firearm on or within an arm's reach of his or her person, a firearm during the commission of or the attempt to commit certain felonies. 1611-131 only requires a more general possession of a firearm. As Judge Whitaker explained, possession doesn't require that you have the item on your person or within the arm's reach. Having control over and intent to exercise control over the item is sufficient. And constructive possession. Pro tip, anytime you see the word constructive in the law, read it as fake. Constructive possession equals fake possession. So they want to change it because it makes it easier to convict, pretty much. Because they don't have any evidence of these guns anywhere near Yak Gotti specifically. And technically the one Shannon Stillwell threw out of the car, apparently. They don't have that either because he wasn't within arm's reach.
I would just strike possession of codeine with intent to distribute and possession of cocaine out of the indictment. I know that it doesn't really matter with regard to Arnold and Williams. I mean, they're on this indictment, but they're not deliberating about them. So it really doesn't matter, I don't think, whether something that those people could be charged with is included or not, because all that the jury's deciding is Mr. Kendrick. So is everybody okay with us just redacting out possession of codeine with intent to distribute and possession of cocaine on the substantive count?
I'm okay with that, Your Honor.
Yes, Your Honor. Okay.
Nothing involving any other defendants should be sent back to them, but whatever. I know it's the indictment, whatever.
You know, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
Yeah, and I'm not, well, I probably should. I'm not disagreeing with the court on what you're saying with respect to that. The real key is going to be if we can find any law and what that law says.
Sure.
That'll be determinative
All right.
of some of
and
those issues.
You say I probably should, but you shouldn't if you, I appreciate that you take your duty of candor seriously. I really do. Thank you. Yes, sir.
Okay, Doug, getting some points there with Judge Whitaker. Oh, here goes Atkins yapping.
With regard to Act 183,
yeah.
If the jury unanimously finds that this overt act was in furtherance of the conspiracy,
yeah.
I believe with the instructions the court will be giving when you have multiple parties and can be in pleas.
Yeah.
And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, it would be attributable against Kendrick and Stillwell. So I believe the state's current belief is that the way it is worded is safe with the instructions the court will be given about possession, constructive, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles. And if they do find this overt act is in furtherance, it will be following that law.
Here's the challenge with that, and just kind of think through this hypothetical with me. We have got Overt Act 183 that says Arnold, Kendrick, and Williams. Let's assume that the only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then the whole case gets reversed, assuming that that's what happens.
So yeah, Judge Whitaker being careful, man. That's what all this is.
I doubt if that's going to come to fruition, but legally speaking, that's my worry with leaving it the way it is.
Understood, Your Honor. I'm thinking through it with the court right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
Overt Act number 3, y'all allege that Mr. Stillwell possessed marijuana with intent to distribute on 8/23/13. Is there a conviction for that? In which one is that?
that is going to.
Isn't it laughable? A 2013 possession of marijuana, intent to distribute conviction. 2013 selling weed. I promise you that has nothing to do with YSL. That is horseshit. All right, the jury's coming in. The judge going to charge the jury.
61, possession of a firearm during the commission of a felony. And 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is a doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who,
Gang experts.
of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it.
The Diet Coke sip. All right. She looking like me. Everyone always commented about me sipping my drinks and shit. Stay out of my business. I can barely talk, man. My teeth hurt.
If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who was merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor.
She gonna have to take a lot of sips, bro. It's a lot of reading. Holy shit, there's 40 more minutes of her reading. I might have to skip that, dude.
RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity.
Okay, that sentence right there makes me think they're gonna definitely put guilty, honestly. Dude, jury instructions, I feel like always favor convicting. Like, it's always gonna sway.
The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang.
Dude, this is scaring me the way she's breaking it down here. I'm like starting to feel like they're gonna do a guilty verdict. Fuck, man. This is starting to scare me.
To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
All rise for the jury.
This is intense. Watch them leave the room. Jesus. She's holding back a few jurors for some reason. I don't know why. Look at this screenshot here. This is crazy.
All right. Y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now, but you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
Oh no, they haven't agreed on the evidence being sent back yet?
Some case law this morning, and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about 2 issues, the CAD reports and the demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay.
My understanding of the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony in terms of that non-testimonial analysis.
And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
So my recollection is completely accurate, as we did have a series when we went through these CAD reports, a series of hearsay objections and confrontation clause objections,
Right.
And some were redacted.
Yeah. All right. So then I think it would be my conclusion that it is all right for them to go out as long as they are all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously.
Having looked at the demonstratives the state plan would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses.
Okay.
Whereas in Ruffin, that was an anatomical chart. It looks like it was used by a medical examiner in the parenthetical.
So I'm looking at, it's a fairly old case from the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State.
Sorry, was that Moore v. State? Yes. Thank you, Mr. Abate.
Weinstein objected to a demonstrative going back, and then Abate fired back with another case.
So I think, unless y'all come up with something else, that I'm going to overrule the objection to both the CAD reports as described, redacted, and demonstratives going out.
Judge overrules all the defense's objections. We are in verdict watch now, boys. The jury has the case now. They're going to decide the fate of Shannon and Yak Gotti. Some intense shit. They only have between 9 a.m. and 3 p.m. the day before Thanksgiving as you're watching this video. If they don't have a verdict by 3 p.m. tomorrow, then they go home all weekend and come back Monday after Thanksgiving. A lot of people are saying they could rush a verdict today as you're watching this video on Wednesday. I don't know. I feel like this case is too big. They're not going to do that in my opinion. So I think we're going to get a verdict sometime next week. So now we wait, boys. Comment down below what you think is going to happen. Hit subscribe. I love you guys. Thanks for your support. Peace out.